Mr. Larsen, I'm not going to spend any time quarreling about the statutory authority for waivers. I'm not even going to discuss the substantive aspects of the health care law. What I want to focus on is the waiver process. Can you tell me when the waiver process was first made public?
Yes, thank you, Congressman. I think, as was mentioned, the regulations that identified the phase-in of the annual limits as well as the waiver process were published, the interim final rules, in June. And within 90 days of that, I think on September 3rd, we published the first bulletin that laid out the waiver process and that laid out what we think were very simple and straightforward provisions of the application process for the public. I think it was mentioned that there wasn't a quote, an application initially. In fact, in order to make the process very simple, we just laid out the types of information that an applicant could provide, and later on, as we got more applications, to improve the process, we did develop a form that people were to use online, a spreadsheet, if you will.
Let's assume it's September 3rd. Were there applications for waivers that were made prior to September 3rd?
Not to my knowledge.
Were there waivers granted prior to September 3rd?
Not to my knowledge. I mean, we didn't have the application process set up.
That's my point.
Right.
Are you sure there were no requests for waivers prior to September the 3rd, 2010?
Requests for waivers?
Request, applications, request.
I've been advised that there were 3.
And what process did you use, given the fact that there was no public process that had been promulgated at that point for those 3?
Yeah, I assume that they were held until we set the process up. That's my assumption.
And when you say process, are you referring to the regulation that used the word large and significant, the words large and significant?
No, when I say set up the process, I'm referring to the bulletin that we issued in September. That was when we identified that there was a process in place. So we issued the reg, and then we established the process through what we refer to as sub-regulatory guidance, which is the bulletin that we put out in September.
So your testimony is that there were 3 applications, whether that's formal or informal, for waivers prior to September of 2010?
That is my understanding, but I'd like to confirm that for the committee.
Okay. So how did the companies know the process before you promulgated the regulations?
Well, again, the regulations were issued in June, and I would say the regulations did 2 things, among many others. This was part of a broader regulation. But with respect to the annual limits provisions, we established the tiered phase-in for annual limits, starting after looking at what was happening in the marketplace and what types of annual limits were out there. We established for the first year the $750,000 restricted annual limit. And again, it's very important to note that the statute specifically contemplates that there will be no annual limits in 2014, but what it refers to as restricted annual limits.
Well, I wasn't going to go to the statute, but if you're going to bring it up, you'll also have to concede nowhere does it grant the Secretary the express power to grant waivers.
Well, I'm not sure I would agree with that, because the clear reading of what is there is that there will be a phase-in of the annual limits provisions.
Well, the word waiver does not appear anywhere in the statute. Would you agree with me there?
Well, I will agree that the word waiver does not appear in that particular section.
Okay. Well, that's the one we're talking about.
But I don't think that's, as a lawyer at least, the normal test for whether it's reasonable to interpret a statute to
speaking like a lawyer, let me ask you.
I know you're a lawyer, sir.
Well, not much of one. I was just a prosecutor. Let me ask you this. If there's a denial, is there an appeals process, and what burden of proof does an applicant have to make to be considered, rejected, and then considered again?
It's actually, we do have a reconsideration process, and again, it's a very simple process. We consistently were guided by the principle of making this as easy and as simple as possible. So we advise applicants that if they are denied, they can ask for there, and we will work with them to collect whatever additional information we need to look at the application again. So there isn't a hard and fast burden of proof, because our goal in implementing this provision was to ensure that employees could continue the coverage we had. So we didn't want to make it burdensome. In fact, if we had to make a choice, our objective would be to err on the side of making sure that people could continue their coverage. So we weren't out to deny people. In fact, we wanted to make sure that people could continue their coverage.
I've run into the red light, so I will